All right, we'll have the next case. It's 22-1670. Paul Flegg, is that correct? Flegg, okay. Versus Coquina Palms Homeowners Association. This is a case in which we've got a cross appeal, so you'll need to divide your time or allocate your time accordingly. We have 15 minutes per side, but if for some reason we need to exceed that because of the cross appeal, we'll do so, but we're going to start with the 15 per side. So please decide how you want to divvy that up. So appellant, when you're prepared and set to go, come on up.
Thank you, Your Honors. Good morning. May it please the Court. My name is Adam Bird. I represent the appellant Paul Flegg in this case. I'd like to reserve 3 minutes for rebuttal if I could do that, please. We've asked through this appeal that the Court reverse and remand an order finding entitlement to attorney's fees and awarding over $300,000 in attorney's fees on a number of bases. The overarching concept here is that parties have freedom of choice in their strategic legal decisions, but they don't have freedom of consequence. And unfortunately, we're left in a situation oftentimes when we make a strategic decision that it has consequences that we can't affect. And unfortunately, in this case, though the appellee, Coquina Palms Homeowners Association, made a number of strategic choices through, I think, what I would call revisionist history of what happened, they've sought to avoid those choices. And I think our appeal makes it clear that they cannot do that. It should be, the orders on attorney's fees below should be reversed and remanded for a number of reasons. First, the appellee never properly pled an entitlement to attorney's fees.
Wasn't that covered in the first appeal?
No, sir. We appealed, Your Honor, among other things, the trial court allowing a post-10-day trial amendment to the third-party complaint against the appellant, which was upheld on appeal, but the effect of that appeal and the belated addition of an attorney fee claim was not addressed on the appeal.
What prevented your client from advancing that before?
I believe we did, Your Honor, we did.
And that's my point. If you did advance it, then it was taken care of. If you didn't advance it, my question is, why didn't you advance it in the first appeal?
We did in the first appeal, and I think, again, the issue, I think, on appeal at that point, our standard, there was abuse of discretion, right, because the amendment had been permitted by the trial court as a post-trial issue. And so the question is, what is the effect, and the question that we've raised here today is, what is the effect of that amendment, the timing of that amendment, right? And the second issue before the court today is, it's our position, and it was our position below, that the amendment didn't correct the deficiencies in the pleading. So what essentially occurred below was, after a 10-day trial on liability, the lower court found in favor of the appellee on one of 3 claims in the third-party complaint brought against our client, my client. And at that point, the appellee noticed that they didn't have an attorney fee claim in the singular count on which they prevailed, had no basis for attorney's fees. And so 4 months after the August of 2017 final judgment was entered, they filed a motion to amend on December 26th of 2017 and sought to add a claim for attorney's fees, lo and behold, in the singular count on which they prevailed.
But that issue was in front of us.
The amendment was in front of the court, correct?
So what you're saying about the delay was already evaluated and vetted by this court in a way that was not in favor of your client. You would agree with that?
Yes, I would agree with that. I would agree with that.
So what you're asking for today, to the extent you're saying it was not covered before, is saying that it should have been said with more specificity in the pleading itself?
I'm saying that the corrections, the amendment that was permitted did not correct the issue. Does not allow for an award of attorney's fees on the bases that were awarded below.
Well, and I know that's some of the subsequent argument you make. I'm trying to understand, though, the amendment was allowed. That issue was taken care of by this court, as this judge understands it. What about the substance of the pleading? Would it be your position that it should have been better elucidated?
Certainly, and we've addressed this in our brief, but there are a number of things. First is the finding on prevailing party attorney's fees, and we're left in kind of an interesting situation here where the trial court has a tranche of attorney's fees that it awarded by prevailing party fee provisions, which I don't think was proper, and then there's a tranche that was awarded pursuant to 57-105 covering a different time period. And so I'll limit my argument since it's relevant to the amendment to the prevailing party fee argument. So the trial court, after remand, awarded attorney's fees on two grounds as prevailing party fees. One was the association's governing documents. They're not referenced in the third-party complaint. They're not attached to the complaint. They're not incorporated by reference in the complaint. And 1.130 says you got to attach what your documents upon which your claims are based. So they didn't do that. So governing documents which aren't referenced in the pleading and are not attached to the pleading, the third-party complaint, even after its amendment, should not have been grounds for a fee award, number one. Number two, there was no allegation of a violation of a fiduciary duty by statute under 720-303, under the Homeowners Association statute. What was pled and what was not corrected by the amendment was a common law breach of fiduciary duty claim. And we cited to the Adler case in our brief where an award of fees for breach of fiduciary duty, common law breach of fiduciary duty was reversed because there's no basis for fees under a common law breach of fiduciary duty claim. And that's why no fee claim was pled here. So when we did the amendment 4 months after the judgment was entered, all we did was add damages, including attorney's fees. That's it. No additional allegations as to what basis there was for fees. No allegation of entitlement to fees under 720-303. And I realize I'm towing a fine line there because there's no requirement that you identify your basis for attorney's fees. But the facts, the material allegations that you allege must...
You would agree that's the law?
That is the law. Absolutely. Caulfield, 100%. That is the law. But there's a fine line when we look at like the Ashcroft case, right? What do we have to plead? We have to plead material allegations that support those claims. So I have to be able to look at the material allegations and see, okay, they're alleging a breach of fiduciary duty under the statute so that I can be aware that there could even be an attorney fee claim, even where one wasn't initially pled.
Are you telling us that was a surprise?
Yes. Yes, it was. The first time that an attorney fee claim was made in relation to count 2 of the third-party complaint was in a dual motion for fees, which was a shotgun pleading filed a month after the August 2017 final judgment that asserted something like 6 or 8 grounds for attorney's fees, pulling anything and everything that they thought might give them an attorney fee claim, a basis to make an attorney fee claim, after they were aware which claim they prevailed on.
And all of that happened ahead of the first appeal?
Yes, sir. Yes, sir, it did. The appeal, we actually did appeal the amended final judgment, but we had agreed that the damages issue would be tried separately below because how the liability shook out would determine who was entitled to damages and who was not. For example, as is relevant to this appeal, our third-party complaint against my client had an indemnity claim in count 1. And in the indemnity claim, the appellee sought attorney's fees as part of its damages under indemnity, alleging if we have to pay the plaintiff below, you should have to give us anything we owe the plaintiff as damages for this indemnity claim that we're bringing against you. My client was an officer of the association board below. That was the only claim, and they did not prevail on it, that had an attorney fee that mentioned the term attorney's fees in the third-party complaint until its post-trial amendment. That was the singular one. So first, we have no allegations that would have even put us on notice, factual allegations, material allegations, that they were asserting a statutory breach of fiduciary duty claim. It's pled as a common law claim. And if you look at paragraphs 94... Forgive me. I think it's 94, 95, and 96 of the amended third-party complaint, the one that was amended post-trial. The allegations are very much reasonable, prudent person. They are negligence allegations. They are common law negligence allegations. And 72303 on the statutory fiduciary duty owed by an officer of an association talks about a willful and knowing violation of the duty as giving rise to fees. Well, that's not what's been pled. In fact, the only reference to 720 at all, there are two in the entire third-party complaint. One says that the association is a homeowner association pursuant to 720, and the other says that my client allegedly received free office space from the plaintiff in violation of 720 subsection 3033, subsection 3, which was never proven, nor was it relied upon at trial, nor was it included in the final judgment.
Did your client file a motion for more definite statement to ask them to further provide specificity as to the basis of the fee claim?
No, sir. We filed a response and objection to the dual motion and we may have even raised it on appeal as well, because there was an appeal that was filed after the August 2017 amended final judgment, which was a non-final order and ultimately resulted in dismissal. But that's where this first came out. We immediately filed a response and objection and said, wait a minute, you pled a common law breach of fiduciary duty claim, you prevailed on a common law breach of fiduciary duty claim, you don't have an entitlement to attorney's fees, and you've never asserted one until now. And the response we got was a gesture to this joint pretrial stipulation that we filed, where we specifically said that parties are claiming attorney's fees as a measure of damages, and that's a reference to count 1 of the third-party complaint, where the appellee did seek attorney's fees as damages in its indemnity claim against my client, again resolved against the appellee below. And so if they had won or prevailed on that claim, I think we'd be in a different situation, to be certain. They know how to plead an attorney fee entitlement. That was another issue that we've raised in our brief. There are other claims, including the ones against the plaintiff below, the actual counterclaim, where they pled entitlement to attorney's fees. So this wasn't an oversight. And we reference even in our brief an amendment that was attempted by the appellee below to amend the third-party complaint before the 10-day trial, which was denied, but even the proposed amended third-party complaint did not contain a prayer for attorney's fees. And the standard for attorney fee pleading is so very light. I mean, Stockman versus Downs tells us, and you know, even this court has the Shenandoah Highlands case that we cite. It's a light standard, but parties are entitled to know what the other side's claim is during the case, because the existence of a fee claim could drive resolution, could drive settlement, could help parties to choose which claims they continue on and which ones they don't. We were never provided that opportunity. That didn't come until 4 months after a 10-day trial on liability. I'd like to preserve the rest of my time if I could, please.
Thank you.
Thank you.
Would you
Please,
like,
the court, I'm
Okay.
Charles. I'm
Go ahead.
Charles Powers for Coquina Palms, and
would you like to reserve any time?
I would like to reserve 3 minutes for the reply.
Very good.
And first, the issue of whether the amendment to allege attorney's fees was a primary issue. I think it was issue number 3 raised by Flagg on the first appeal. It was fully briefed, and he claimed there was prejudice and he didn't know and so on. All those issues completely briefed and rejected by the lower court and the higher court. That it was within the discretion of the judge, and the judge that granted that was Judge Rainwater, who was the trial judge. So she was very well aware of the facts and circumstances, and the stipulation to bifurcate the case of the parties specifically said there would be attorney's fees in the second part of the case. So the parties were all ready to try the issue of attorney's fees before the amendment. So there wasn't any prejudice that he keeps arguing about relative to this
And
case.
to the extent there was any prejudice, that was already evaluated by this court.
Totally evaluated and rejected that it was within discretion of the court. In this argument that he's saying that this was a common law claim, they repeatedly argued motion to dismiss, motion for judgment on the pleadings in front of Judge Maxwell, the first judge, on the basis that the count was governed by the HOA statute, and that the standard was knowing and the court evaluated the count 2 and said it met the statute and rejected that claim. That claim was their argument number 6 on the appeal, that they said it didn't rise to the level, they didn't adequately allege the standard of willful and knowing breach of the fiduciary duty in count 2. That was argument number 6. And we responded saying, we agree it's a claim under the statute, but we did allege that it rises to that level, and this court rejected that. Judge Maxwell rejected that argument. Judge Rainwater rejected that argument. 3 judges on the prior appeal rejected that argument. Judge Dugan on remand rejected that argument, and now they want you to overrule all those rulings. The complaint specifically says, as he said, alleges 720.30333, which, by the way, I wanted to clarify, the actual amended third-party complaint was attached to the motion to amend, but it was actually filed later, and it's at record 4236, and the numbering is different because it's just a third-party complaint, and it leaves off all the other counts, but the original complaint, answer to the original complaint, counterclaims, and so on. So anyway, it says in paragraph 12 that alleges that 720.3033 paren 3 was violated, citing that statute, and because he didn't mention that's a self-dealing statute, that's an anti-self-dealing statute, and it said in that particular paragraph that he had an improper rental agreement with Cinco that was self-dealing. But later, when they get to him, it alleges in 16 that he acted in furtherance of the scheme, that in 15 that he was acting in concert with Cinco in furtherance of a scheme to recoup the insurance proceeds. That's self-dealing. And then that he acted in furtherance of that scheme by filing this lawsuit and helping Cinco. And then in 30, paragraph 30 specifically says he breached his duty of loyalty and was improperly self-dealing. And the statute that prohibits self-dealing was already cited in the count. We didn't have to cite the statute a second time when we already cited the anti-self-dealing statute in an earlier paragraph. And and then goes on to say that in this lawsuit, he was specifically improperly helping Cinco. He had taken the HOA's records and refused to give them back so that we couldn't determine when these minutes were created, because the CDs that electronically restored information was in those records that he took. And there was an eyewitness, the prior lawyer who had known him and been dealing with him for years, said he had him at the deposition of Cinco and was helping Cinco with them and wouldn't give them back. That was alleged and proven. That he was contacting witnesses. He was involved in improperly, he took the complaint and scanned it into his computers, and he knew the lawyers and knew all the other board members and never emailed the complaint to him, and they were defaulted. And then he helped Cinco for 2 years fighting the default. And we said right in there, he's helping Cinco fighting the default in this lawsuit. And we said that he was creating false minutes, helping Cinco in this scheme for self-dealing. That's a violation of the statute that was alleged by section. And they're still saying, after 6 judges overruled this, 6 judges have said it states a cause of action under the statute, and they're still, even after attorney's fees, and they're back there saying, oh no, we're surprised about this Chapter 720 thing. It's just stunning, really. The lack of,
Counsel, if I could have you turn to your motion for attorney's fees in this case, in this appeal.
Okay, yes, sir.
On which bases are you seeking it? Are you seeking it for the various statutory ones, including 57105? Or just tell me a little bit more about it.
Yes, there's attorney's fees under, it's 720.305. It's the HOA subsection that says where there's a knowing violation of duty, and in a case between an HOA and a board member, and there's other provisions, but in a case between an HOA and a board member, the prevailing party can get attorney's fees, and we prevailed under a 720 claim. So there's that. There's also, on cross appeal, I brought up the wrongful act issue, which I'm going to retain some time on, and then there's, unless your honors want to go into that now, and then there was the covenants. On the covenants, they cite the Tolinsky case, saying that if it's not attached, in the Tolinsky case, that's the one they rely on in their brief. In the Tolinsky case,
So I want to make sure I get an answer to Judge Makar's question.
Yes, sir.
Was not another basis below 57105?
yes, there's 57105, there's the covenants, there's the 720.305, and there was the wrongful act. Yes, sir, which was already dispensed with, but I brought that one up.
There was no response to your motion in this court,
My motion,
your motion for appellate attorney's fees.
not that I'm aware of. And your honors,
And again, to clarify, you're pursuing 57105 in this proceeding, is that correct?
yes, if it would be, it could continue, yes, sir, in this.
So maybe you've got a few minutes, just a minute or two of why their appeal is in violation of 57105.
Well, you just, there's the issue of the, fact that they're arguing, for example, that the counterclaim did not rise to the level, and that's already been argued in the previous brief. They argued again, that the amendment, and it's been raised, it was dispensed of in the previous appeal.
I'm sorry to interrupt. Would the award of appellate attorney's fees be any different under either of the two statutes?
I don't believe so, Your Honor.
So it really doesn't matter then?
It doesn't matter, they're all those are
Okay,
bases.
well, then maybe go on to something else then.
All right. Under under the damages issue, where they say that we didn't allege attorney's fees, as we said that we wanted damages including attorney's fees. Specifically, if you look at the reference to the amended complaint at paragraph 31 at record 4245, that's the factual allegation says, as a result of the breach, Coquina suffered damages and incurred attorney's fees and costs, not including. The including language is in the wherefore prayer for relief clause. And the case they relied on is Supreme Court case Chasen versus Ritchie, which they cited for other reasons, but they cited this very point that it's the allegation, factual allegation of the complaint that matters, not the addendum prayer for relief clause. And we said damages and attorney's fees, and they made a big thing about the fact that it said including in the argument, so therefore we waived the. But Ritchie says it's the allegation that's in the actual count, the factual allegation that matters, and if there's an inconsistency with the wherefore, then the facts prevail. And they cited that case.
Counsel, if I could interject, I just noticed, I probably should have seen this before. This case was filed in 2011?
Yes,
In the
sir.
trial court?
Yes.
And last I looked, we're in 2023. This is
What?
This is a 12-year-old case?
Yes, and the fire it's based on is 2005. This is almost 20.
Well, tell me this.
Yes, sir.
This is simple arithmetic. How much damage was awarded in the action? Damages, not attorney's fees.
The only damages that were awarded were our attorney's fees, and that's what was overturned for the wrongful act.
So am I hearing you correctly? This entire 12 years of litigation is about attorney's fees?
Yes,
There's
because
no
the
damages.
underlying case was brought by Cinco based on a fraudulent claim. Yes, sir.
So the arithmetic on the attorney's fees is how much has been expended by both sides in this case?
Well, counsel was close to $500,000 when it was, according to his testimony and his production of records on the last time, and I don't know, he's probably $750 by now. We were at, I'm on a contingency. So
Well, it's just me speaking, the one judge speaking.
Yes,
Having
sir.
done homeowners association litigation for much of my career, I'm a little concerned that this is burdening the court system over what appears to be almost like, gamesmanship and a hobby to litigate.
Not for me.
That's maybe too strong of words, but it sounds to me that's what's going on here.
Well, we're trying
We're
to...
not here to settle grudges. We're here to settle cases with legitimate disputes.
Well, when he fomented a case improperly with a third person, and we expended, we were only awarded $150,000 or so for that action. We actually spent it was at the $350,000 level when, after judgment on liability alone, that
Counsel,
they actually spent.
Counsel, don't misread me, because I could be speaking to the other side as well. I'm talking from a broader perspective.
Yeah, it's terrible, Your Honor, that this case was fomented against them by, because he realized there was some money that he could get there, and he made this deal with this guy to sue them, and then took the records out of the warehouse, and then destroyed his computers. That's what because once he found out he was
Counsel,
going
was
to be
there
brought
any
in.
mediation in this case? Was there any trial level mediation?
Multiple mediations. The only reason I'm in this case, Your Honor, and the testimony is in the record, so I'm not talking out of school here. The only reason I'm in this case is because the HOA could not pay the last final bill, and I testified to this because I'm a member of the community. They were going to go forward with no lawyer because they couldn't get a dismissal of this case.
We may be getting outside the record here, but Counsel, I've taken you over your rebuttal time.
Yes, sir.
So if you'd like to have the full 3 minutes and conclude right now and sit down, I'll give you the full 3 minutes.
Unless there's any other serious questions, I'll be happy to retain my 3 minutes. Thank you.
May it please the court. I think the question's a fair one, Your Honor, as far as why we're here, and I want to bring that back to the initial questions that I was asked about the amendment and this attorney fee issue, because that is why we're here. I identified these issues when I objected to the dual motion for attorney's fees filed in September of 2018, and I identified in my response and objection the fact that they didn't bring a claim under 720 and they didn't attach the governing documents. Now, they amended their third-party complaint after I filed that. Why didn't they add breach of 723.03, breach of 723.05? Here's the governing documents. They were permitted to amend. They chose not to do that. I started my argument by telling the panel that we all have to deal with the consequences of our choices. Okay, I told them what was wrong with their third-party complaint when I was surprised by the filing, and they didn't fix it. They could have easily, and they chose not to. And that's why we're here today.
Well, both sides have to deal with the consequences of their actions.
Yes, sir, we do. Yes, sir, we do. The question about why this case is what it is, it was a fact-intensive case. My client was on the stand for almost 5 days himself as a result of questions from the association's counsel at trial, which was not Mr. Powers. There was a great deal of facts that really covered a 4 or 5 year span. My client was alleged to have done a lot of very dastardly things that we had evidence, and we believe the evidence reflected, turning to the 57105 issue, that he did not do, and that those issues were contested. And if I could just touch on that issue briefly.
But isn't that history? I mean, we're here on, that litigation is long gone.
Yes, sir, it is, except for the award of 57105 attorney's fees against my client as a result of what the trial court dubbed a frivolous counterclaim. And our counterclaim was a single count defensive counterclaim seeking only indemnity under the HOA statute should my client prevail below. That's all I brought. He was a board member at the time. He was entitled to the protections of the statute. So his case, the facts and the law were not so frivolous as to render his counterclaim, his singular defensive counterclaim, frivolous. We were the victim of revisionist history there as well. I think the trial court's order on appeal reflects that the trial court relied on what happened at the trial on contested issues and evidence to award 57105 fees against my client, which is improper. We cited to those cases that say you got to look at when it was filed and you got to look at whether there was a colorable argument. And I'm sure the court's familiar. Most 57105 cases come down against 57105 and its application because of the chilling effect it can have on litigants. Simply because we lost a trial, we shouldn't be stung with over $300,000 in attorney's fees when they were not pled. When the basis, once they were, a claim was pled, a barren claim without support was pled, and then we use looking backward to try to figure out how can we generate that claim? How can we get those fees? And that's what happened below and why it should be reversed. Thank you.
And you can address the cross appeal issue.
Yes, Your Honor. The issue of the relation, or of the wrongful act fees, again, I think I argued that, but under Caulfield, it's very clear that you don't have to allege the legal basis of a claim for attorney's fees, and it did request a claim for attorney's fees, and we relied on that Supreme Court authority. And I'm aware of no authority whatsoever saying that you have to, other than this case, saying you have to plead, specifically say wrongful act when the facts show a wrongful act. And I sent some supplemental authority. On the other issue of relation back, I sent supplemental authority on the relation back issue, excuse me, and under the relation back, they're arguing that it was, or I think the judge's thought was that it would be prejudicial to relate it back, but
Complaint didn't have a request for attorney's fees?
yes, I'm sure that he thought that from the time, I'm not going to relate it back because it would go, but the rule requires relation back, and the Supreme Court said in Caduceus and in
Well, in those cases, I'm well familiar with those cases, counsel.
yeah.
Typically, let me give you a medical malpractice example, because that was my former life. But
Yes, sir.
you bring a claim for medical malpractice, nursing care, and you want to add an additional nuance to that, maybe not dropping an IV bag when the doctor ordered it. Well, that relates back because the same facts, same claim. Here, the fees were a new claim. This was of a different kind, and the cases, as this judge understands them, those would not relate back. Different claims would not relate back. Why is that? Why is that not a disqualifier of your argument?
Because and I believe it arose out of the same fact pattern, and it was based on all of the same. Nothing factually was changed except it specified that part of the claim was the attorney's fees, which is in the statute. And if that is a separate claim, then I don't think it is. I think it arises out of that fact pattern, and the discretion was to deny the motion to amend. And the Supreme Court makes clear that that's where the discretion is. If it would be unduly prejudicial, then you don't grant the motion to amend. That's been established. Now it arises out of the facts. It's just a mechanical thing. It gets related back. That's my point on that. I think that's what the law should be. And I think that's what the Supreme Court was trying to say. And then...
Counsel, you're about running out of time here.
Thank you very much, Your Honors.
Okay. Well, we thank you both for your arguments. We will be in recess.
Thank you, Bob.